Hi, Rodney Peyton here, and welcome to Beyond the Gavel. Today's conversation brings a distinctive voice to Beyond the Gavel. My guest is Carlos Stecco. He is an accomplished medical malpractice attorney whose career has traversed the full landscape of healthcare litigation. He's gone from insurance adjusting and defense work through his years with an in-house counsel at Johns Hopkins, and now he's a principal in his own firm, representing patients and families across Maryland and Washington, D.C. Now, what makes Carlos particularly compelling is not simply the breadth of his experience, but the way he draws upon it. He evaluates plaintiff cases with a defense lawyer's eye, and because he's been looking at the medical side, he's a clinical respect for the realities of practice and has a steep commitment to ensuring clients receive a clear and honest appraisal. His background in managing sentinel events, advising medical teams, and steering negotiations at a senior institutional level gives him a rare vantage point, one that blends legal acuity with the understanding of the pressures facing clinicians. So in this episode, we're going to explore the reasons behind his shift from defense to plaintiff practice, the emotional and ethical tensions inherent in medical negligence work, and the discipline required to remain objective while dealing with profoundly human stories. For lawyers and clinicians alike, his reflections offer valuable clarity on how cases should be assessed, how communication failures can escalate into litigation, and why early expert screening remains so critical. So it's a pleasure to welcome Carlos to Beyond the Gavel. Thank you so much for being here today.
Thank you, Rodney, for having me. I look forward to speaking with you.
That's great. Now, you have that wide career, as I mentioned there. How has that shift from the defense side to the plaintiff work? What key moments kind of prompted that shift? And how has that influenced in the way you practice at the moment?
Well, I did defense work for about 8.5 years as an attorney, and prior to that, I was a medical negligence insurance adjuster for about 4 years. And so I was very grounded on the defense side. And there came a time where we tried a case. I tried a case with my mentor, and we were able to get a defense verdict for one of our physician clients, who we liked to call him a frequent flyer. He had had several cases, and we'd always gotten a defense verdict for him. And we did the same thing in this case, and it was time to then report back to the insurance company. When I did, the insurance company, I thought they would be very happy with the result, but the response was essentially, why did you not get him out of this case sooner via motions practice? And that just, it hit me the wrong way, because this wasn't a client that I had chosen. This client was assigned to us. And so it really struck me that it was time for me to do something in terms of medical negligence work where I would get to choose my clients and help them in any way I could. And so that was really a turning point for me in the sense that it really opened my eyes to the notion of choosing my own clients, because continuing to work for this particular insurance company was really a thankless job at that point.
Yeah, it's thankless, and you're sort of put into it. And a number of people, we've talked about relationships. I mean, what you wanted was autonomy. You wanted your right to choose and to be involved in those cases you wanted to be involved in because somehow they rang a bell with you. Isn't that right?
That's
So
right.
it was that autonomy that gets you to set up your own business. And I think that's what a lot of business owners in the legal field do. So in-house counsel with the Johns Hopkins, I mean, that must have been a profound influence on you, because you understand not just what it is from the plaintiff's point of view, but that there are two sides to this. There's the medical side, the nursing, and all the rest that they're involved, who didn't set out to hurt anybody. So how has that influenced how you look at duty breach and the consequence?
Huge impact for me, because yes, at Johns Hopkins, just a fantastic institution and a place where honestly the sickest of the sick come from all over the world.
Yeah.
So I dealt with a lot of incredible practitioners, nurses, physicians, therapists, uh, every one of them. And so it really opened my eyes to what it was like on the front lines for these healthcare providers. And so doing that type of work, and then after that, being in private practice doing defense work, when I use that now, so when a client, a potential client contacts me, the first thing I do is try to analyze it from the defense perspective to try
Hmm.
to figure out what are the pitfalls involved in pursuing this case from the plaintiff's perspective. So I put my defense hat on first, try to analyze the case as I would from the defense side to see if there are any potential avenues of success for the plaintiff here. And when I talk to potential clients, I explain that to them. And I think it helps us to analyze the case. It helps the clients to feel comfortable with the sense that we, on our end, are looking at everything from every angle so that it creates the best chance of success moving forward for the client if we move forward.
Well, I think that's very important, and it's very difficult initially, isn't it? Because there's some sort of equilibrium to be got there between. I mean, people feel they've been hurt, and they don't understand why a lot of times, and they don't know if they've a case or not. And then they go to you because they just don't understand. It's about communication deficit a lot of times. So how do you decide whether you're going to take on a case or not, and how do you balance that obviously emotional side that these people are in because they've been hurt or they feel hurt, and it's a very emotional thing for them? How do you balance that out with what you say is deciding, well, one, two, three, it has duty, breach, and damage, and all that as a sort of system, that emotion versus our practice?
Yeah, and I believe that the vast majority of potential clients that contact us think they have a case. They think they have a case. It's rare when someone calls us and says, I don't think there's anything here, but I figured I'd talk to a lawyer to find out. That's not usually what we get. And so the emotional aspect is always there because they feel they have been wronged or their loved one has been wronged in the medical arena. And so that's the hardest thing to learn, I believe, where I sit, is to not let your emotions take over your analysis of the case. They just can't. If you do that, if you're a solo practitioner, you'll be out of business pretty quickly. You can't let your emotions take hold. And so I I remain as objective as I can. I analyze the records as they come in myself, but I also consult with healthcare providers that we consult with. We've got a team of physician assistants that help us analyze cases and give us, I like to say, they give us a roadmap of where the case might go, whether it's a case that seems to have a breach in the standard of care with causation and damages. Because I try to explain to potential clients, although there may have been a standard of care violation here, that may not be the cause of your injury. Or if it was the cause of your injuries don't warrant pursuing a case like this because these are expensive cases to pursue.
Yeah.
And one saying that I have to potential clients that have either limited damages or they've improved, they've recovered, as I say to them, you have to think of it this way. In a medical negligence case, good recovery and good health equals not a good malpractice case. Bad
Yeah.
recovery, bad health equals a pretty good malpractice case. What would you rather have, Mr. Potential or Miss Potential Client? And they always say, of course, they'd rather have their health. And I've used that a
That's true.
lot, and it helps for them to see how we analyze a case initially.
Do you help them to see those stages? It's very interesting because traveling around the States and things, you see these big hoardings, somebody smiling said, my lawyer got me 15 million. I said, you wouldn't be standing there smiling if you got an award of 15 million. There's something badly wrong if that's what it was. But you get, these ads, he got me this and thumbs up and all the rest of it. You know, no real client, as you're saying, that has been badly hurt goes on a billboard and smiles when they get that amount of money. They are not in good shape.
Yeah.
So there's a lot of fakery going around in that, and I love your approach where you're saying, let's be clear right up at the beginning. And the way you do your screening flat out, I mean, some may notice I hurt my eye there. I got a shuttlecock in it, and it dislocated my lens and things. Now, I have been in surgery a long, long time, and I know a bit about eye surgery. I mean, I had to learn it. I had to learn the books. I know the anatomical structure. But when I went to eye casualty, and when I went to see my colleagues who are ophthalmic surgeons, I don't know what the exact mechanism of the pressures are, which lenses they're going to use to do the things in. I don't know it all. And yet the number of times I talked to attorneys who said, oh, well, we know these cases, we just assess them ourselves. But I love what you're saying. You have actually physician's assistants that you use to go over. Some cases are routine, but you use to go over these to give you a steer right up front. Isn't that right?
Yes, absolutely. Now, of course, some cases I don't need to do that.
Yeah.
We can tell right from the beginning that it's not a case to pursue. But yes, when it's beyond that, absolutely, I'd rather have a healthcare provider looking at those records and maybe figuring out what we're missing, what just doesn't seem right, in terms of let's say it's a surgical procedure and notes are missing, anesthesia notes might be missing, whatever it might be. That's what they're trained to do. I've become good at that over the years, but again, I'm a licensed attorney. I'm not a licensed healthcare provider. So I am guided by what the healthcare providers tell me in terms of whether or not this is a case to pursue. And what we do as well, Rodney, is, I tell potential clients, and then, I tell potential clients, we're going to get you answers. That's what we're going to do. At a bare minimum, we're going to get you answers. And so at the end of the day, it may not be the answer that you want to hear, but you will get answers from us as to what happened to you or to your loved one. And people appreciate that. One thing that I frankly take pride in is the cases that I turn down. I will send that client a detailed letter explaining why we are not pursuing the case. And I can't tell you how many times during that conversation, because I'll have a conversation with them before we send the letter out, or even after they get the letter, that they say to me, they thank me for that and they appreciate that, because then they can put that issue to rest. And of course, they have every right to have another lawyer look at it. But most of the time, they tell me, I think you've answered all of the questions thoroughly for us, and we're ready to move on. And oftentimes, I've gotten referrals from those clients that turned out not to be plaintiffs because we didn't pursue the case. And I think that goes a long way with people, just getting answers and figuring out what happened.
Yeah. And I think that shows your depth, and you're using experience over ego. Your ego says, I take them all on, I know what's going on. But your experience and how you use your medical experts and that active listening to your client, where you will take some time to sit down with them, listen. And sometimes that's what we're missing in the medical profession. You don't sit and listen, and completely interrupting them and moving forward and saying, just here I am, tell me from your point of view what you're feeling, and I will understand. So I think that's so powerful what you're saying there. I mean, that really is important. And you have written, I mean, you've got some very significant cases that you have gone through. What do you think? A lot of them are sorted before they get to court. So what facilitates a good early resolution in your mind? And what do lawyers most misjudge, against that opportunity of getting it sorted early on? What have you seen?
Well, I think it's important to have the right uh, the first of all, the records speak for themselves in those types of cases.
Yeah.
If you've got the right set of records, meaning you can see a smoking gun in the records, that helps. And then the clients themselves, of course. Um, what backgrounds do they have? Are they working? Do we have a younger person who's not able to work again, that left, that has a family that they can't support? In wrongful death cases, do we have, again, young people that left a family behind? And honestly, in cases involving older people as well, we handle a lot of nursing home negligence cases. And some attorneys may write those cases off because those are older patients near the end of their lives, and that case may not be as worth as much money to me than the case involving, a younger person with a family. But that's a wrong way to approach it. Those cases to me are just as valuable because they go to that's when you can really tap into the emotion of jurors, because you talk about the dignity of life, right? And the dignity at the end of life. So there's so many factors, I think, that go into those pre-litigation resolutions. Frankly, a lot of those cases involve institutions rather than individual defendants. I think those types of cases seem to be the types of cases that may settle prior to litigation. Hospitals have a different way of looking and analyzing cases, I think, than insurance companies representing individual defendants. And so we've had more success with hospitals. We work with different hospitals in the area routinely on different cases over the course of years. And it's important, I think, to have relationships with these people. Whether they're hospitals or insurance companies, it's just important to have good relationships. I really try to handle my cases and approach my cases and my interactions with opposing counsel and treat them the way I'd want to be treated. And if they need an extension on something, sure, that's fine. It's not going to make or break the case if you have an extension of 15 days. That's fine, because I may need that down the road. And so I think relationships with opposing counsel, relationships with the decision makers, whether it's insurance companies or hospitals, vitally important to keep those lines of communication open. And that helps with these pre-litigation settlements. And it helps with settlements in litigation as well, because cases settle while in litigation all the time. So it's important to have those good relationships with the professionals in your line of work.
Isn't that interesting? Because we're talking about relationships with the client, we're talking about relationships with the other side. And I think the other R in there is respect.
Right.
Where you respect everybody, that you're humble enough to you put your case out, you don't filibuster, you don't yap and yell at people, because you're going to have to see them again, especially with the big companies and the hospitals. You're going to be seeing them again, and people don't forget. And I think one of the things when I'm talking about branding, it's your personal brand. What people say about you when you're not there. And they say, look, Carlos is a great guy to work with. He's been very fair and very honest. If I were you, I would do it. That's what's said about you behind your back. And that is your brand. And really, most lawyers need to understand that. It's not just writing letters to people. It's about knowing them. It's about having those relationships and having that profound respect for everybody in the process, including the court, including the jury, that actually gets you through.
Absolutely. I really, really strive to maintain good relationships with opposing counsel, with decision makers at these hospitals or insurance companies. At the end of the day, my case is not going to settle if the other side chooses not to do so. It's up to them, right? I mean, they're the ones that control the purse strings. And so it's important to have good relationships with these people because it benefits your client. At the end of the day, we have to do what is in the best interest of my client. And if resolution is in the best interest, great. If going to trial is in the best interest, that's what we'll do as well. It's got to always come back to the client, and building these relationships is all part of that.
So it's not even for that client, it's the next one and
right.
the next one and the next one. One thing you point out, one client talks to another, and the other thing is the insurance companies talk to each other as well. So I think that's a great theme, and you've demonstrated what it's like to start in the defense side, to be within the hospital environment, the institutional environment, to learn what's happening on both sides and understand that two lots of people are hurt in some form. No doctor I know gets out of bed wanting to hurt anybody. And they're hurt when this happens just as much. And anger and things all comes from that hurt. But the way you come across and the respect that you give leaves them intact as opposed to being shattered. And I think that is one big message I would give to all lawyers around the world that listen to this podcast, is to treat everybody with respect and to watch your own ego.
Yes, absolutely. And I've been there back in my hospital days and my insurance company days, preparing doctors for depositions, preparing nurses for depositions, for trials. And I've seen what they go through. I really have. And I consider that in these cases. Flip side, now for the last almost 17 years, I've been representing patients and preparing them and seeing what they go through. So yes, I think I've seen it all, and I've seen how it affects both sides for sure. But I at this point, I'm happy that I made the switch 17 years ago to representing patients and their loved ones. I just find it makes a big difference to me, because I can just see what a difference it makes in the lives of these clients when we either get them an answer or get them a favorable resolution at the end of the case.
Carlos, that's just wonderful. I think our audience will have appreciated very much the depth of knowledge and the way that you have tackled this. I think there are a lot of excellent points that they need to think about in their own practice. Understanding that it's a business, understanding you can't bankrupt yourself, understanding about listening, careful listening, finding answers for your client, and that builds your reputation and your brand. Carlos, thank you so much for being with us today.
Rodney, thank you for having me. I appreciate it.